Hello and welcome to our Mom Life TV panel discussion, A Guide to Life, Legacy, and Divorce, Taking Control of Life's Transitions. I'm Sandy Pellin, the CEO and founder of Mom Life TV. We've come together today to focus on thriving during challenging times. Our life throws us so many curveballs between starting a family, going through a divorce, or even losing someone. And these moments are really tough. It's not just about change, but often it's about facing a whole new reality for us. So I'd like to start with this quote from author Louisa May Alcott. "I'm not afraid of storms, for I am learning how to sail my ship." And our experts today will share their wisdom on handling life's big shifts. They're going to share their thoughts, ideas, and expertise across three key steps: facing reality, goal setting, and establishing an action plan. So before I introduce our panelists, I just want to remind everybody that we'll take questions at the end. And I also have a disclosure that this panel discussion and material does not constitute legal advice or engagement with either attorney on our panel today for services. And now I would like to introduce our attorney panelists who are from Chicago, Illinois. Jennifer F. Kuzminski, who's a private client trust and estate partner with H&B Legal Counsel. With over 20 years of experience as a trust and estates attorney, Jennifer helps individuals, families, business owners, and entrepreneurs transform their wants and needs into goals with a plan to achieve them. Jennifer counsels families with generational wealth and individuals, often executives, entrepreneurs, and C-suite executives of middle market businesses. She helps her clients with their estate planning for tax-efficient wealth after death, assists with their not-for-profit organization formation, and advises them on estate and gift tax matters. Welcome, Jennifer.
Glad to be here. Thank you for having me.
Yes, thank you.
Nice to meet all of you.
And our next attorney is Kathryn Mickelson. Katie is a divorce and family law partner with Bierman LLP. Katie Mickelson is an equity partner, first chair trial attorney, and certified mediator at Berman LLP, who represents her clients, their complex financial estates, and sensitive family matters with the utmost discretion and confidentiality. Miss Mickelson treats every case as an opportunity to educate her clients and promote financial and emotional dignity. From business owners to professional athletes to some of Chicago's most influential rainmakers, Miss Mickelson's clients come to her for her reputation amongst colleagues and judges as a prepared, responsive, and attentive to the smallest of details. Her ability to listen and to hear her clients and then convert these goals into real results contributes to her prominence as one of Chicago's most influential family law attorneys. Welcome to both of you. And now that we've met our attorney panelists, let's dive into the discussion. Now, with any major transition, you really have to take stock of exactly where you are in order to figure out where you're going. We'll begin our discussion on this topic of facing reality and the best way to do so. Now, the first step when something big happens to you is you have to start to look for your team. So our first question will be, what should someone be thinking about before someone finds and hires the right professional or attorney? Katie.
Well, well, first of all, thank you for having me. So I appreciate being given the opportunity to be here. I think what's really, really important in this process, given how emotional this is really kind of taking ownership of the process. Really understanding why one is here to begin with, and ultimately understanding that while it may not be a choice, it's something that ultimately is put in someone's lap. So taking ownership of that process and experience is very, very important. It may not be pleasant. it might be incredibly difficult, but that ownership actually gives people back control that they feel like they're missing in the process. Understanding that family dynamics are going to be involved in this whole process. So it's not just about the person in the case of a divorce who's going through the process and is going to be affected by a marriage breaking up or parties separating. Potentially, there's going to be additional dynamics that have to be considered. And that's not just children. If the parties have children together, it's actually the family unit. And in today's day and age, a family unit can actually encompass a lot of different types of individuals, and it might not even be by blood. Understanding really what kind of process one might have to undergo. I think it's difficult for people to understand that going through a divorce can be incredibly complicated, not so much because of the emotional components, which obviously complicate things, but the process itself can have a lot of different pathways. For example, taking stock in what type of divorce you might be facing and what you would prefer it to be. It wouldn't be any surprise that I get many people saying they want to fight because they've had a lot of difficult experiences coming to where they are. And perhaps they might not be the person who wants the divorce. Perhaps they might be the person that's been harmed or hurt in the process. So determining the idea of what type of divorce you kind of envision for this to be. Do you believe this is going to be a collaborative or cooperative process? Most common is the word amicable. That's a most common type of descriptor that people will use. Do you think this is going to be adversarial? Is there a need to, I'll call it fight? And that's, as we'll go into later on in the conversation, fighting is really actually not in the best interest of the parties, the children, the extended family. And really in that approach is finding an attorney that aligns with whatever your needs are. So I always say to people, it's very, very important to interview attorneys to find out who is the right fit for you, because that's going to set the tone for the case and ultimately allow for you to proceed in a certain manner. And while one person might say, I'd like to be adversarial, I'd like to fight, an attorney should be able to talk to them to say, here are the pitfalls, for example, of going through a very adversarial process. And most importantly, I would say the fit. And I think I allude to that in finding the attorney. You need to find somebody who will fit with your approach. It doesn't necessarily mean agree with everything that you have to say, but has a similar mindset, whether it be that you are going to be seeking a cooperative approach, whether you have some challenges that you're going to need for somebody to be stronger in the courtroom, in a mediation setting. I think all of that is very important. We're not supposed to be approaching this with an ego. It's a very, very difficult process. And we all have to be prepared to put our egos aside and say, what's the best for us and for our families?
Yeah, absolutely. And you spend so much time, they really become your team. So you want to make sure that you're a good fit. And Jennifer, as far as that same question in estate administration, would it be a similar approach?
A little bit similar, yes. You kind of have to figure out who you are as far as estate administration goes. This is after someone passes away. Who you are in the process. Are you the person in charge? Are you detail oriented? What kind of family dynamics are there with your siblings if it's a parent's administration? If it's just your spouse, it's probably, going to be just administration. You're going to be in charge and you're going to take control. But you want to find an attorney that goes with your style, right? I mean, if you are type A and you are going to be detail oriented and drilling down into every detail, you're going to want an attorney that's going to be responsive to that. If you need a little more gentle hand, you're going to want an attorney that's going to guide you and like kind of tell you what your next step is and give you, as much or as little as you need to process at this grieving time, whether it be your spouse or your parent that has passed. You're going to want to kind of gauge the type of personality. So you don't want to just interview maybe one attorney. You want to maybe speak to 3 attorneys and figure out who you're most comfortable with, because you're going to be spending a lot of time with that person and you're going to be talking about very personal things. If it's a family, if it's a person that has a parent who's passed away, you're going to be dealing with sensitive family dynamics with siblings. Maybe there's a sibling that lives with parent. And maybe that sibling needs to move out, and it's going to be who you're comfortable asking questions to, talking about personal things. Same with estate planning. You'll want to assess your attorney as far as what your needs are. If you are a fairly wealthy person, you're going to need a more advanced planner. You can't just go to someone who just does volume practice estate planning. It's not going to be estate planning in a box, easy peasy. It will be more complex. It will have tax issues. You'll have to figure out how you're going to handle liquidity to pay taxes later. Different kind of attorney than someone who is just merely processing through the assets and having them get to the right parties later. So, it's much more of a complex attorney that you'll need if you're in the taxable brackets. If you're not, and maybe you'll need to talk to a few to figure out where you do sit, because you might not really know what that is. You'll want to be comfortable talking about your personal goals with that person for planning. What you see as your legacy, maybe that's making sure that your children are taken care of and that they don't have to worry, and that somebody is supervising that through their lifetime to a certain age. Maybe it's that you want to leave a legacy to charity. Everybody has different goals. I've had people have pet trusts that leave a portion to a caregiver to take care of their pet or their horses or something like that. Everybody has their own goals, and with that, you want to choose an attorney that is the right fit for what your goals are and your personality.
Yeah, absolutely. There's so much emotion that gets wrapped up into these life transitions. So it's really how we handle such the delicate situation is, it's obviously of the utmost importance. Jennifer, when counseling a client on the death of a family member, whether it's a spouse or a parent, what would be those first steps that ease the process?
So when I'm counseling a client and they've had a death in the family, whether it be their spouse or their parent, the first thing I tell them is, because I often have clients come to me and they just want to get started. They want to get cracking. They're just raring to go, because it's like the only thing that they feel like they might have a modicum of control over. But really, it's time to take a moment, be with your family, give yourself a little grace and time to actually grieve and recognize that things have changed. Parents no longer there, spouse is no longer there. Wrap your head around that a little bit before we actually delve into details, because if you hit the ground when you're still kind of in the air, you're not going to take in any of that information. Your body and your mind can't focus. You're not going to be able to listen to what I tell you to do, and really not going to be able to execute on any of it. So the first thing I tell people is to give themselves a little grace, to actually take time to grieve and talk to their family, before they, run at it. If I do give them something to do, the first things I tell them, I give them very small tasks. Like, for example, after the funeral, make sure you order enough death certificates, 12 death certificates, or if you have a lot of little assets, maybe even 2 dozen. Make sure that the house is locked up, and that if you need to, change the locks, because maybe other people have access to it, like a housekeeper or a neighbor. You want to secure that. So, pretty common sense things locate the paperwork if you can. These small items are things that people can handle, not getting into the weeds of the assets and how that's going to go. Or, we don't usually, people see on TV all the time a reading of the will. Everybody gets in a room and they read the will, and it's dramatic, and that doesn't usually happen. I've never really done a reading of the will with my clients over all these years. Generally speaking, they have this time period with the funeral, gathering a few things. Somebody takes charge and gets the paperwork together, and then we call a meeting and circulate the documents so everybody can see what's in the documents before we have the meeting. And then we discuss what's going on and who's in charge, and maybe they need to decide on someone declining to act as executor, or certain decisions. But that will be at the first initial meeting, and that's when I give them more jobs. At the outset, it's real simple. Get some death certificates, secure the house, find paperwork. That's pretty much, tax returns and wills and trusts if you can find them.
Yeah. Okay, that's really good information. And let's move to transition. The death of the family member is probably one of life's most difficult transitions, but so is the death of a relationship. That's just as tough in some cases, especially with children involved. Katie, let's move to you on this. When someone comes to you, you must see that people are overwhelmed and grieving the loss of that relationship. So how do you start this difficult process with them?
So slowly and gently. I mean, I think you've hit on a really good point of this is the mourning of the loss of a relationship. I think what's also really difficult about it is that person is still around. That dynamic was still there. And sometimes with the death of a family member, while not quick, there can be at some point some closure that ultimately lessens the pain each day. But especially when you have a dynamic where, say, a parent is going to be continuously present because you have to co-parent or something along those lines where the ties remain, it's very difficult. You don't want to hire an attorney to act as a therapist. That being said, because I always say I'm a very expensive, ill-equipped therapist for you to hire. I don't have the training as a therapist. That being said, I am a human being. I understand that relationships are incredibly complicated. And like Jennifer said, most of the time, if I was to jump in with legalities and my statutes and certain things that people need to consider when they're going to be going through a divorce process, they shut down. No one's going to be listening to, for example, terms that we need to reach as it relates to allocation of assets, or anything with regards to child support. You're not going to be listening to that because you're going through a mourning process. So what I have told people is that, oftentimes, and I've heard this so many times, that, people who are going through a divorce, they appear almost, like they're not thinking logically, and they feel like they're going crazy. And one of the mediators that I often mediate cases with likes to tell people that indeed they actually are going crazy, because when you are under extreme stress, the hormones and certain things are released within your body that actually affect your brain. So that fight or flight mechanism, everything that causes you to either freeze, fight, flight, is that same concept. And I think with a divorce process, people really aren't thinking clearly. So I have to be very careful in how I talk to my clients or potential clients to not overwhelm them. It's the same thing of what Jennifer said. So I usually allow space. I let for people to talk a little bit about what has brought them before me. Most of the time, we're not talking about legal issues yet. Most of the time, I'm trying to understand the dynamic. Why are you here? It's the why. And sometimes people can't really enunciate the why. I mean, it might not be their choice. So the why might not necessarily be something that they've chosen, or they're not there specifically because they want to be there. It might have been thrust upon them. But understanding that dynamic and understanding that and recognizing that the process is difficult, recognizing that it's not all about legal issues and that we're going to take it one step at a time, I think is really comforting to people. Plus, like I said, I'm a human being. We're all human beings. We understand that human relationships are really complicated. And there is no relationship like another relationship. And so the things that are happening behind closed doors in one household is going to be very, very different from what's happening in closed doors in another household or relationship. So what I really try to do is I try to calm. I try to set a baseline and say, you're in the right place. Let's not focus right now on all the tasks that you need to get done. Let's consider, give me a feel for the case, give me the basic facts. Tell me a little bit about yourself. Tell me about your children. Tell me about your relationship. How did you meet? Tell me what are some of the things that have happened recently that have brought you to this point, whether you know it or you don't know it. And let's talk about the personalities of the parties. It's really, really important for me to understand your person, if you're my client, your personality, as well as the person that's sitting across the table from me. Because in any divorce process, whether it's amicable, contentious, mediation, cooperative, litigation, you need to understand who it is that is negotiating against, because that often changes the tactic of how you address that person and the goal setting, which I know we're going to talk about next. So, like I said, calm, set a baseline, I'm not here to flex my legal muscle and show everybody how smart I am. I'm actually trying to really connect with my client to say, it's okay, you're in the right place, and I'm here to help.
Great. Thank you both. So we've established some best practices and ideas on that idea of facing reality. But now as you said, we're going to shift our focus to the future, and that is about goal setting. So goal setting can be really tricky in situations like divorce. And Katie, how is this goal setting different when you do talk about divorce? Is there a one size fits all for goal setting for your clients? Or
yeah, and
only about
certainly not. No, yeah. Certainly not. And as I've alluded to before, we're all human beings with varying different circumstances. It also depends largely on roles that people have taken in the marriage. And I know we're just today focusing on divorce, and family law encompasses a lot of other issues, and there's a lot of other transitions that happen in family law. But when you're focusing on the divorce side of it, really depending upon, I approach it from a couple of different tactics. One, I'm looking at the parties involved and what roles did they specifically play in the marriage. And I want to say that with a caveat that our roles are fluid. So we might, there might be a stereotypical breadwinner. There might be somebody who's the homemaker, but generally those individuals actually vary in their roles, and it's very nuanced. So somebody who might be a homemaker actually might be the person who's paying the bills, right? So it's not like they are completely out of control and have no knowledge, and stereotypically, if it's a woman, they're not a kept woman, right? So there's obviously responsibilities that people are undergoing. And so I need to, though, really understand who it is that I'm representing. And so if I'm representing, for example, the wage earner or the business owner, those goals are going to be very different from somebody who is, say, is a bit more dependent financially on the other spouse to provide. So, for example, with a business owner, my goals may be if they have an ownership in a business along with other partners, how do we protect that business and insulate the partners from having to deal with fears that it's going to do something to the business and cause disruption? If I am representing I'll call it stay-at-home parent, the goals may be, how do I ensure that we have a stable environment to continue living in, or to continue to have access to the home that, say, if there's children, that they've been accustomed to? Or how do we address what your lifestyle has been like? Knowing that you're not the primary breadwinner, how do we maintain a lifestyle in a realistic way? So it really depends on who it is that I'm representing. And ultimately, everyone's goals are going to be very, very individual to him or her. There's going to be, in that process of setting goals, I'm going to give my clients tasks to do that ultimately help them identify those goals. And that might be a preliminary identification of documentation, identifying, certain things that as it relates to their home, ultimately figuring out where is it that they want to live, ultimately saying what's realistic about what your current living situation is. Considering anything that you've thought about for your future stability. Is it, if you are, for example, the dependent spouse, is it important for you to stay on an amicable plane with the other party because that person might be a source of support for you in the future? So that is something that I will, along with the goal setting, I'm trying to unpack the issues to allow for somebody to say, okay, I have this goal, and how do I attain this goal? One thing that I always think is really interesting is I represent a fair amount of business owners, very, very smart people. They don't even have to be business owners. They can be parents who are taking care of the children at home, very accomplished, very, as I'll say, they drive the bus, they drive the bus and the family, and they're used to being in control of the process. One of the things that I have found, which has been very, very difficult, is that feeling of out of control. It's like learning a foreign language, and that is very, very disarming to people because they're used to being in control and they're used to understanding the lay of the land, their kids' schedules, their business, how their family dynamics work. I think it's really, really scary. And when you come at it with goal setting, it allows for people to recenter themselves and say, okay, I know I have been very good at this, but I want to accomplish that. And as part of the process, how am I going to accomplish that and feel a little bit more in control? And I'm not going to guarantee that the feeling of control comes back during this process all the time. It kind of ebbs and flows. But I want my clients to leave these meetings feeling like, you know what? That was not a waste of hour. I actually feel empowered, and I feel like I can kind of move on and I can address the intricacies of my divorce and not feel like I'm a deer in headlights. So that's why goal setting is really, really important. And it's also just very individual to whom I'm speaking.
Yeah, thank you. That was great because it's just really good information to think about when you're going through something like that, which is tough. Jennifer, a death in the family is obviously a very difficult situation to deal with. And getting your clients to focus on the next steps at hand, how do you counsel them to focus and set their goals?
Okay. So, like Katie, sometimes, depending on who you're representing, it changes the tack, right? If I'm representing just a beneficiary in a case where we're not actually in control of the administration, it could become a little more adversarial. And, our role is a little bit different than when we're representing, say, an administrator or an executor in an estate. But generally speaking, in our meeting, in our first meeting, we'll discover who is actually in charge according to the documents, if there are documents. If there are not documents, the statute of the state that you're living in will decide who has priority to petition the court for administration in a probate. So, probate is when you only have a will, or if you don't have a will, the court will help you transfer your assets from the decedent to the people that are supposed to receive them. And if it's an intestate estate without a will, those people are determined by law, by the statute, and it's called usually the law of descent and distribution. Depending on the state, it could be heirs or heirship or something like that. If they have a will, you still need a probate, still need a judge, governing things, but the will actually tells the court who the decedent wanted to take control. So it might list 1, 2, 3 people in a row of who they would pick to take control of the assets. So the document decides in that case. Now, if you have a living trust, which is a little bit different, that operates during life and after death, that's a private proceeding. And that document will also name who that person wanted to be in charge. Now, that being said, maybe person number 1 in either the will or the trust says, I have a lot on my plate right now. I do not have the bandwidth to do this. Then they can decline to act and the next person can step up. So part of that first meeting is deciding, is this person the right person for this role? I let them know, what the responsibilities are of that executor or trustee, and do they think that that first person is the person for the job? And if it's without a will, then we talk amongst the people in priority as to who should be the person taking the reins. And sometimes there's disagreements as to that. So that can be kind of a hotly contested thing. So it's good to have some documents there to help guide the people that you leave behind. Now, that being said, the next step that we talk about is any kind of emergency or pain point. For example, if you have a decedent that had an operating business, and that business has employees, and who's going to be the person that can take charge and start hitting the ground running, making sure that all the insurance is paid up and things are taken care of. If they're, like I mentioned before, if there's someone living in the home with the decedent, and we have to now find different housing for this person because that home is going to be sold, or maybe that person is going to buy the home. But we have to start discussing these painful things kind of right off the bat, because you only have kind of a limited amount of time to do this. And after that's why I wanted people to take the period to grieve, so that we can talk business a little better at the time they get to me in that initial meeting. In that initial meeting, I'll usually give the person who the group decides is going to take charge a few tasks. And then we're going to set some maybe monthly or bi-weekly meetings, checking up on if they've accomplished the tasks, what they need help with, moving them along in the process. Because you're not alone. Your financial advisor will be hopefully part of your team, your attorney, accountant, all these people will be involved in the administration of an estate. Even if you think you don't have a lot of money, the logistics of things definitely require professionals to help you, at least guide you to go the right way. They sometimes can check in every month. It doesn't have to be a ton of time. Maybe it's a half an hour huddle, but definitely to get you moving the assets to where they're supposed to end up, so that you don't end up with missing deadlines and emergencies and taxes not being filed that need to get filed, and be responsible as an executor. Don't be afraid to lean on your professionals and your team for this. Basically, that's the message in the first meeting, is that you're not alone. Here are a few things that you can do. This is the checklist, and it will show you what your attorney is going to do and what your accountant's going to be in charge of, and what you should be in charge of. And then we're going to meet and talk about it again in a couple weeks or a month, and then we'll move you along the process. So, and then any questions they have, we take that in at the same time.
Great. You really broke down all the steps and to give guidance on that. So that was very good information. Now that we faced our reality and setting goals, let's transition to the action plan. So our goal today is for everyone here to walk away with some clear, tangible steps. And let's start with discussing what's the first step for everyone. Jennifer and Katie, would you like to discuss why a personal balance sheet and asset inventory is important for each of your clients as an initial starting point? Jennifer?
You want me to take it first? Okay.
Sure.
So for basically for both things that I do, the estate administration, it's important to know what we have that we need to take care of, whether it be a business, a home, life insurance, accounts. A good place to check is the income tax return. It will show you a lot of where the assets live. So that's like an asset inventory, just a sheet with a list of assets and how they're held, whose name they're in, how will help us decide how we need to approach things and what's most important first in an estate administration. With a planning piece where we're deciding how to plan someone's estate, we also need to have that personal finance balance sheet so we can see, what's in this spouse's name, what's in the other spouse's name, how is it held, how much is there going to be a tax that's due when somebody dies that we need to make sure that there's enough assets to pay the tax. Maybe we're evaluating if they need some life insurance. Some of these things come up when we see all of our assets on one page and we see how they're titled. You might realize that all the assets are titled in husband's name, but maybe we should have some in spouse's name, wife's name, for that, to balance it out and also to give some security on that person's death, that they're not just left with a deer in headlights situation. So that's really important in both the administration of an estate and for the estate planning purposes. We can also evaluate, if you're taxable, what we can do to make that optimized and less taxed in your planning.
Great.
And Katie probably has her own thoughts on this.
Yes.
For divorce.
Yeah, Katie, can you share?
Yeah, I mean, a personal balance sheet's going to be important. I mean, I think that Jen has alluded to why it's important from a planning perspective. Frankly, nobody really plans to get divorced. It's not generally within our, if you get married, you're not saying I'm going to live my life as if I'm going to go through a divorce process. I think, though, it's a smart planning tactic because ultimately, if you are faced with the reality, you have a good understanding of how certain assets are titled, because what's happening in a divorce process, really simply put, is we are ultimately going to put things on a balance sheet. And we are ultimately, at least in Illinois, just to make this very clear, every state has different laws as it relates to the divorce process. So not every state is going to be the same as Illinois. There are similarities from state to state, but for example, in Illinois, a family law attorney is going to ask a client to put assets on a balance sheet and ultimately allocate them in an equitable manner. The difference is in other states like California, marital assets are allocated on a 50-50 basis. It's called a community state type of approach. But in Illinois and other states where the equitable concept comes into play, we're trying to first categorize, identify assets, and ultimately determine if it's a marital asset, if it was an asset that was acquired during the marriage, which is defined from the day you marry to the day a judgment for dissolution of marriage is entered, that's going to be an asset that possibly could be allocated. And same thing with debt. So it's, I referenced this before, is that we're not often thinking clearly and we forget and we think, oh, I forgot about this account. I have this retirement asset that I haven't thought about. Making sure that you're organized when you're not under a tremendous amount of stress, very, very important, because then you're being really thoughtful about what it is that you have and also how it's titled. One key point is just because something is titled in one spouse's name doesn't mean it's not a marital asset. If it was acquired during the marriage, regardless of title, at least in Illinois, it's considered a marital asset. Or at least the presumption is that it is a marital asset, which can be rebutted. But ultimately, what I suggest with personal balance sheets is I think it's helpful in a couple of different ways. And when I think of a personal balance sheet, I think of categorizing what it is that you own, from accounts to real estate to cars to retirement, investments, anything that has a value, even life insurance. And as we know, term life insurance doesn't have an inherent value, but a whole life policy would maybe have a cash value. Putting that on a balance sheet to really determine what does it look like and how is it titled. And the same thing for debts. It really allows for you to, if the inevitable happens where you go into a divorce, you can confidently say to your divorce attorney, I estimate my estate is worth X, or I estimate that I have these types of assets versus these types of assets. And you come in, and it helps organize things when you meet with your attorney to have done it with a very clear mind. So I think personal balance sheets can be very important from that perspective. I also think, while not necessarily a asset balance sheet, what is often helpful is, well, and I would have to say, from a budgeting standpoint, this is obviously helpful for everyone to see where their money goes on a monthly basis. But one of the things that we are identifying during a divorce process is, how do we spend our money? And that's really, really important as we're thinking about, where does our money go on a monthly basis? And that's helpful when we're determining issues with regards to support, both for spousal support and also for child support, if children are part of the relationship. So having that information before you when you're in a calm state helps you not only just be organized, but in the event there is some type of event where you are facing an issue in a relationship, and that you need to be more organized to address that, you will have done it at a time where your brain is thinking more clearly and you're not in that moment of stress.
Yeah, thank you. So let's just recap, because we've gotten some really great information here today. Jennifer, what's your takeaway or checklist for our audience today?
Okay, so I'm going to give you a little checklist as for planning, because obviously we all know we're going to pass away someday, but the way to help get yourself and your parents or your spouse into the right position for others to take care of things in administration is to start planning correctly. So the first thing that I'm going to tell everyone is to talk. That it sounds silly, but start talking to your parents and your spouse and your business partners if you have them, and start talking about how you would like things to be if you're not around, who you'd want in charge. Let's discuss who's the best person for this. Maybe you want to discuss that with your spouse. Who's the best person to take care of the kids? Who's the best person to be in charge of money? Who's the best person to make healthcare decisions if for some reason we get in an accident together? Who's that person going to be for us? They can be different. Business issues, succession. If I'm gone, how will my spouse and my loved ones take a part in this business? Maybe we need to think about having some sort of agreement, like a buy sell, and maybe an insurance policy to make sure that my family gets the benefit of this business that I've built over the years. So first is the talk piece. Second would be to now let's find some people that you get along with and that you think can serve your family well if you're not here. Assemble your team. So your financial advisor, your accountant, your attorney, maybe your therapist, you can have a holistic look at this as to, find your people that you're comfortable with, and people that you think your family can rely on. And let the family know who these people are. Leave a list of people. That's great. So first is talk, second is assemble your team. And then, third is to make this plan for yourself now. You'll need, everyone needs a revocable trust, a will, and powers of attorney. I know people say, oh, I don't need that. I'll just do joint tenancy, or I'll just put a beneficiary on my IRA, and I'll just put a beneficiary on my account. But that can actually cause a lot of problems and pitfalls. You can unintentionally disinherit people by doing that. Mom, your parent puts you as child on, an account jointly with her on a deed of a house. All of a sudden that's your house when they pass, and the value of that house doesn't get stepped up in basis. And now all your siblings are wondering, like, why, when you sell the house, do I get part of it? And is that person obligated to gift, ethically, and not by law? They don't have to. So it can cause some really unintentional results. And no matter what you think people will do, it's not always what they will do. And I've had a lot of litigation about that over the years. So, it is good to have a plan in place, have powers of attorney for if you're sick or incapacitated. Somebody can take over finances, can take over your health decisions. What does it mean to put it in trust? People say, oh, put that in trust. Well, there are a couple different kinds of trusts. There's revocable trusts, which are changeable during your lifetime while you have capacity, which if you become incapacitated, a successor trustee is named, and they can jump right in, and they can write the checks for you, and they can sign your tax return, and they can do all of the things that you need them to do right away. And then also after death, the trust document tells the trustee what to do. Whereas, a will only operates after death. So it's a very different type of document. It's only post-death, whereas trust will operate during life. And by putting it in a trust, it means that you're actually changing the title on your investment account to Jennifer Kuzminski as trustee of the Jennifer Kuzminski Trust. And it looks kind of ridiculous, because we're like, it's the same thing, right? But it isn't the same thing. You are using your own social security number. You claim taxes like you normally would, but on your death, it's not you as an individual. And the law will not require a probate of that asset if it's actually titled to your trust. So on your life insurance, you'd put your trustee and your trust name, and it will be my successor, as trustee of the Jennifer Kuzminski Trust, that will take operation and control over that. But it basically takes the court out of the process and allows it to be a private process that's much more streamlined and less expensive. So you'll pay a little bit more up front. You'll do a little bit more work up front to get those assets into your trust. But that being said, it's going to save the work for the people you leave behind. They're not going to have as much complexity, and it will be much more private and less expensive to administer. So, that's the third thing, is to get yourself some documents. After you've gotten your people, have the people talk and decide, help you decide what's best for you in your documents. They'll also look at, whether or not you're taxable and whether or not you need additional liquidity to pay taxes. Also, if you have difficult property, they'll identify that. Do you have digital assets? Do you have crypto? Do you have out-of-state property that needs to maybe be in an LLC or in a trust so that you don't have two probates going on? All these things can be kind of dealt with at that meeting, getting the documents together.
Great. Thank you. Lots of good information there too. Katie, what was your takeaway or checklist for our audience today as far as divorce goes?
So it's a little bit difficult, because I'm often, it's more common that people will come to me, they're actually going through the process. So I want to first start with the fact that it's always important to have prepared yourself for ultimately, if there is going to be a demise of a relationship. That can be ultimately determining before you get married whether you're going to need a prenuptial agreement. That could be a whole other long conversation, but a prenuptial agreement is not just made for wealthy people. A prenuptial agreement actually defines rights and responsibilities should parties get a divorce. So if a checklist most basically is, if you haven't gotten married yet, consider and speak to an attorney about the point of having a prenuptial agreement and defining some of those rights before you get married, and so that you can have more control over the outcome. A prenuptial agreement will not address everything. It's not going to address child-related matters. It's not going to address things as it relates to visitation or parenting time, decision-making, and anything child support related, but it does actually provide you with guidance on what happens in the event of divorce or even death of your assets that you have prior to the marriage, or even that you acquire during the marriage. If you are already married and you anticipate that there could be litigation and there's a potential for some type of a divorce, consider a postnuptial agreement. A postnuptial agreement is going to be very similar to a prenuptial agreement, but the parties are already married. We don't have a statute in Illinois that attaches to and guides us on a postnuptial agreement, but most basically it's a contract that's going to be governing what happens in the event of a divorce. And again, I really want people to understand it's not just for people who are very wealthy. I think there's a misconception that such types of agreements are really relegated to the very wealthy and the very rich and people who have significant assets or income to protect. So what I also think is important is, similar to what Jen had said, have a team in place. If you haven't gone through the process, have a team in place, whether it's an accountant, a financial planner, an estate planning attorney, so that you have all these advisors in your immediate access to advise you on how you should be structuring your estate, what you should be doing with your money, how things should be titled. Ultimately, speak with an accountant about what's the best way to file taxes and ultimately is the most beneficial, especially if you have a complicated estate. So making sure you have that team in place. And this is before even a divorce happens. This is before us even thinking about the possibility that a relationship is going to be changed. Having those people in place, again, avoids the rushing in the event of some type of an unfortunate event where, say, the relationship is not going to survive. Now, I always say, nobody wants to be running around and trying to vet divorce attorneys when you're hit with being presented with a possibility of divorce, because it's very emotional. And as we talked about earlier, you're not thinking clearly. And so being very thoughtful about having that team, and it might include having a divorce attorney as a consultant, especially if you feel that things are going to be, that things might not be in that positive mind space in the next few years. When I am actually counseling a client in the divorce process, I really encourage them to frame their mindset to think, what is the end result that we're looking for? And quite simply speaking, if there are children, we have to solve for issues regarding parenting time and decision making, and we call it a parenting plan. If there ultimately, if there are no children, and regardless, what we have to put in together is some type of a financial document that's going to analyze and allocate assets to each party, divide up and allocate debt, assign certain property, determine if there's going to be support paid, whether that's alimony, which is now called maintenance, or child support or child-related expenses. So I encourage my clients to frame their thinking by saying, what are we trying to solve for at the end? What ultimately is it that I need? And from that, we can move backwards and say, ultimately, if that's what we need to solve for, what are the supporting documents that I need to ultimately come to that final resolution of the case. That is going to include gathering ownership documents for accounts, determining if you've got your access to your tax returns, the deeds to homes, mortgages, anything that's going to really talk about how life has been lived and how assets have been owned. So gathering, and I think it's a good practice because most of us don't keep these documents. We think, okay, well, we can access them online. And, it's important to know that many documents aren't kept beyond 7 years. And when you have a situation where it might not be necessary that you need it, if a marriage lasts longer than 7 years and you have to go backwards and identify how to access certain account information, keeping that information is really, really important. So accessing those documents, figuring out where the various sources are to get access to those information. Because like I said, if we're trying to solve for a financial document to determine what exists and how are we going to allocate it, we have to show ownership of those documents. Of those assets. When we're dealing with a parenting plan, and this is again only when people have children together, I always encourage people to keep a diary. Write down what's been the various parental responsibilities that have been observed by the parties. Write down the children's schedules. Do a day in the life of, and who takes care of whom. Write down the children's doctors, their friends, their schooling, ultimately their activities and who's coordinating those activities. Because what we're trying to establish is what is in the best interest of the children to ultimately continue on a caretaking function. And whether that is taking care and making decisions together or somebody having sole decision making, you want to have a record and you want to keep it in real time. Because ultimately, again, when your brain is going a million miles a minute, and it's very difficult because you're just trying to keep it together because you're in the process, those things are very, very difficult to keep at the forefront. So have a diary, write down things that happen. Keep it, make sure that you're keeping it in current time. It's always hard. I have many clients who, they write from memory, and oftentimes memory, especially when you're going through a really difficult process, is going to be tinged with biases. And there's nothing wrong with that. It's just you want to, as the family law attorney, be able to present really accurate information because ultimately, again, we're trying to get all that information into a parenting plan. We're trying to get it so that the allocation of parental responsibilities, is what we call it in Illinois, is consistent with what's in the kid's best interest and what's been happening historically, both in the family dynamic just in the prior months before the filing and what's going to continue. And ultimately, that vault of facts that I've talked about is very, very important because as a family law attorney, I'm a storyteller. I'm trying to persuade the court in the event there's an issue with regards to some type of dispute that needs to be resolved by the court. I'm trying to have the court feel comfortable that they have sufficient facts and documentation on which to rely on to make certain decisions. So I tell my clients it's not just for me. It's for ultimately, if we have to litigate issues or if we have to substantiate certain claims, you want to have documentation, you want to have backup or evidence that's ultimately going to support whatever your position is. So those are some of the checklists that I tell my clients of what they need to do, both in preparation for having a healthy marriage and being knowledgeable about what's going on in your relationship, and also in the unfortunate event that that relationship breaks down.
Thank you so much. Both of you had just amazing tips, information, and your checklists are, something that every woman and mom can use. We never know when something's going to happen in our life. We can't prepare that we're going to end up being divorced, or that someone, whether it's a spouse or a parent, is going to die, and that some of these steps aren't in place. So you really kind of outlined what we need to know, and our audience will really appreciate that. So I want to thank you both for being here today. And I look forward to, talking with you again. And if there's any closing things that you would like to say?
Thank you for having us. We've loved having, here. If anybody has any questions, they can always reach out to us on our LinkedIn, through LinkedIn, or, through our law firms. And, we'll answer if we can. If it's very fact specific for you, might have to engage me. But if not, we can generally give you some general direction of where to look for the information.
Yeah, and I echo everything that Jennifer said. And I have to tell you, I think these are hard topics. And I think it's really important for people to understand that we understand that. And there's not going to be a one size fits all for any type of human being, family situation. And ultimately, the best thing that we can do is provide information and empower through information. That makes people feel like they're in control and that they can get through such adversity with grace. So that's what I just wanted to.
Thank you both. And we'll have your contact information and your websites both on Mom Life TV. And with that, thank you everybody for being here today. Really appreciate it.